So it's my honor and pleasure to chair this panel. My colleague Aurelio from SMU is going to be presenting his paper on insolvency law in the Global South, lessons for the Global North. An exciting title that I think will be quite provocative and interesting. And Akshaya from ANU will be commenting on his paper. So to not take any more time, I give the floor to Aurelio.
Yeah, thank you. Thank you so much, Dan, and thank you for the opportunity to be here. I have to confess that when I was about to submit the paper, I wasn't sure whether submitting a paper on corporate governance, strictly understood, or corporate insolvency. But they said, well, it's a pity that we're not having more conversations on insolvency law in Asia. So that's why, given that we have the most prominent corporate law scholars here, and many of us see insolvency law, corporate insolvency law in particular, as part of corporate law. So I thought it would be useful to present this paper here. And the motivation for this paper, as you can see from the title, sounds familiar to something that Professor Mariana Pargendler has been writing about, right? Which is corporate law in the Global South. So part of the motivation for my paper was her fascinating work in that space. But also, part of the motivation came from the work that the Asian Corporate Law Forum does. Because as we heard yesterday from Dan, part of the motivation to create this amazing forum is that we are all familiar with the fact that the traditional corporate law debate has been dominated by the US and the UK, the Western world. But actually the same has happened in insolvency, in corporate insolvency law. We can see the influence of Chapter 11 everywhere. We are in a country, Thailand, that has adopted provisions from Chapter 11. We can see the Chapter 11 provisions also in the Chinese bankruptcy code. More recently, Malaysia, Singapore, Europe, Colombia, Brazil. I can continue. So we can see the influence of Chapter 11 everywhere, but not only the law, but also the academic thinking in insolvency. When we think about the academic theories, even in corporate law, when we think about, well, we have the stakeholderism or stakeholder-oriented approach, and we typically think about, Colin Mayer and many other corporate scholars. When we think about shareholderism, we think about Milton Friedman and more recently people like Lucian Bebchuk and others. But with insolvency, it's exactly the same thing. We have the Elizabeth Warren, Jay Westbrook kind of group, which is the equivalent to Colin Mayer in corporate law. And then we have Thomas Jackson, Douglas Baird, Robert Rasmussen, Alan Schwartz, and many others, which are more the equivalent to Lucian Bebchuk and Milton Friedman in the corporate law debate. So the same theoretical framework, the same theories have also been imported in Asia and more generally in the rest of the world. And when we think about legal transplants, we can even see the influence of the global north in a more intensive manner, because we can see, for example, the law of Nigeria, Ghana, and Kenya basically replicate the UK insolvency framework, even though Ghana and the UK have nothing to do in terms of market and institutional environment. There are no similarities in terms of market institutional environments, but interestingly, they have similar laws and proceedings. Malaysia has literally replicated the insolvency framework that Singapore has. So for those of you who are familiar with the new restructuring framework in Singapore, I have good news. You don't need to study the insolvency framework in Malaysia. You already know that if you know the insolvency framework that Singapore has. There are some minor differences, and one proceeding like the company voluntary arrangement that doesn't exist in Singapore and it exists in Malaysia, but it's basically the same. China and Thailand, inspiration from the US, more recently Brazil from the US. Brazil has also some inspirations from some European countries. Uruguay has adopted many years ago a reform that was partially inspired by some insolvency debates in Spain. Something interesting about all of these legal transplants is that they all move from the global north to the global south. So that's why I thought it would be interesting to explore the implications of this, and maybe to try to learn a bit more from the global south, and maybe, who knows, there is something interesting in the global south that can even inspire some reforms in the global north. So as we all know, Kragman and Hansman wrote this influential piece on the end of history of corporate law, anticipating this convergence in the design of corporate law and moving toward a more shareholder-oriented approach. Then we know from Mariana Pargendler that she has been emphasizing that maybe actually it seems that the opposite is happening. And the world is converging more toward the stakeholder-oriented approach, or at least in recent years, we have seen more countries adopting stakeholder-oriented provisions. But the general idea is that the world is somehow converging, whether it is for adopting more shareholder-oriented, stakeholder-oriented provisions, or in the insolvency world, converging toward Chapter 11 in the US or similar proceedings. But we can see many of these similarities. We can see more countries adopting the preventive restructuring frameworks existing in Europe. We can see more countries adopting provisions from the US Chapter 11. There are many factors that have influenced this convergence, this global convergence. International organizations have played a key role. Actually, the doing business was suspended a few years ago for some issues with the collection of data, some ethical concerns. But actually, even from a methodological perspective, the doing business already had many methodological issues. The new report that the World Bank has published, the Business Ready report, the report replacing the doing business, addresses many of those weaknesses. But something interesting about the doing business is that it has encouraged many countries to adopt some of the features included as international good practices in the doing business. And actually, interestingly, many of those features are features from the US Chapter 11. So that's why many countries, in order to improve their position in the doing business report, have been adopting provisions from Chapter 11, even in the market and institutional environment in the US and in those countries adopting those provisions is totally different. Regulatory competition has led to a certain degree to convergence on insolvency law. The US has been a leader when it comes to corporate restructuring. We can see companies like Philippine Airlines, companies like Latam from Chile, Avianca from Colombia, many others restructuring in the US. And the UK said, well, we cannot and we don't want to be behind the US. So that's why the UK decided in 2020 to modernize its insolvency framework, adopting some provisions from the US. Europe said, well, we don't want our companies to restructure in the UK, so if our companies want a more competitive restructuring ecosystem, let's do it. So that's why Singapore also, in its ambition to become an international hub for that restructuring, adopted many of these provisions. We can see regulatory competition leading to a certain degree of harmonization in the design of insolvency law. So why is the global north influencing this? It's just because of consequences of colonialism and legal origins, that maybe Nigeria, Ghana, or Kenya may want to look at the UK. It's just because the US is better than the rest of the world, and that's why maybe we should look at the US. It's because countries maybe in the global south want to replicate the economic success of the global north. Of course, that ignores the basic concept of correlation and causation. Actually, I will mention in a minute that maybe some countries in the global north have achieved that level of economic development, even though they have probably very inefficient, value-destroying insolvency systems. Despite that unattractiveness of the insolvency system, maybe they have been able to achieve that economic success. And then lesson 101 in comparative law. Even if something works in a country, that doesn't mean that will work in another country with a totally different market, legal, economic, cultural, institutional environment. So that's why when we look at corporate insolvency law in the global south, and particularly corporate insolvency in the global comparative debate, I thought that, well, actually I found Mariana's paper really fascinating, and that's why I inspired part of my interest in this project, because she said that the Global South has been basically ignored in many debates in comparative corporate law. So in the past few years, we have seen more interest, particularly from the BRICS economy, and more specifically in China and India. But actually, we don't see many papers in the international debate when it comes to small economies in the Global South. And actually, the Global South represents 85% of the world's population. So first of all, it's a bit sad that the debate is not really inclusive. Also, sometimes the debate in these countries is even more needed, precisely because these countries need to promote more active policies to promote growth. So that's why we really need more debate in that space. And then something that Mariana has found, and also I've confirmed in the insolvency space, is that the Global South has done many innovative stuff that can even inspire some debates globally and also in the Global North. So she emphasized, and this is something that my colleague here mentioned in a fascinating paper, saying that Asia, there is no need for Asia to be woke, because Asia was already woke before the Global North, and particularly the US and the UK, started to speak about stakeholderism. So stakeholderism was here before the Global North suggested that. And actually, Mariana also said that part of the reason for the Global North maybe speaking now about stakeholderism is because they are facing problems of inequality and insufficient state capacity, maybe to deal with some societal problems. And actually, some of those social institutional problems are the problems that we have observed in the Global South for a long period of time. So maybe the fact that stakeholderism emerged from the Global South was precisely as an innovative response to address some problems that maybe governments were unable to respond. Actually, something that I found very interesting in the fascinating discussion yesterday with our colleagues from Taiwan, from Korea, from China, and from India, is that we heard that Korea and Taiwan have traditionally embraced shareholderism, and India and China have traditionally embraced more stakeholderism. And that's actually consistent with maybe the fact that stakeholderism can be more justified, or governments are more willing to embrace these approaches in countries where governments fail and where there are many weaknesses in the institutional environment. So that's why part of the motivation was, well, does Mariana's ideas and hypotheses about this innovation in the Global South apply in the insolvency context? And if so, I decided to go, and explore an additional question, which is, if we find some innovations in the Global South, can we learn something? Or can we get some learnings for the Global North? And actually, when we think about this, and I will mention, there are so many fascinating learnings from the Global South that can inspire the debate in the Global North. Unfortunately, the debate in comparative corporate insolvency law is dominated not only by the Global North, but by the same jurisdictions in the Global North. When you read a doctoral thesis, when you read a monograph, when you read a paper speaking about comparative insolvency law, it's always the same. The US, the UK, and Europe, particularly Germany and France. And then you add an additional country if it is your jurisdiction. So it's like, come on, the Global North is something else. Actually, Canada is a country that has some interest in insolvency provision that maybe should inspire also some debates in the Global North. But the Global South, totally ignored, even though more recently we have seen India and China. And actually, something that I found very interesting, even fascinating, I would say, is that when the Global South think about Chapter 11, they think about Chapter 11 with admiration. They say, oh my God, Chapter 11 is kind of a paradise of bankruptcy. It's like, should be the paradigm for everyone, because it's such an efficient, effective, proceeding that, is good for debtors, is good for creditors. So that's why there is idea of paradise of Chapter 11 envisioned in the Global South. Interestingly, if you ask our colleagues in the Global North, some of them have been saying that Chapter 11 should be abolished because it's so inefficient. And actually, some of our colleagues in the corporate law world, Lucian Bebchuk, Matt Rowe, in the 80s, they wrote about Chapter 11 saying, this is so costly, this is so lengthy, that leads to a lot of litigation, a lot of cost, should be, if not abolished, at least revisited. Other people, like Robert Rasmussen, Douglas Baird, Alan Schwartz, many others, I can continue, have been saying that Chapter 11 should be revisited. Other people even abolishing. So that's why, and at the same time, in the Global South, we are all admiring Chapter 11. But actually, the situation is not much better in other countries. When we think about insolvency law in the UK, Spain, France. Actually, I've said in another paper that a common feature of insolvency laws around the world, and insolvency proceedings in particular, is that they are all generally costly and lengthy proceedings. So that's why I found this misperception about what the Global South believes that Chapter 11 is, which is this ideal, fantastic, beautiful horse that we can see here, and the real picture of Chapter 11, which is the reality leading to the criticism and leading to all of these debates that something is wrong with Chapter 11 and needs to be revisited. So that's why the Global South believes that this is a paradise, Chapter 11 and the Global North, but actually insolvency law in the Global North is not the paradise envisioned by the Global South. There are similar problems, costly proceedings, sometimes even more costly than the counterparts in the Global South. Stigma of insolvency. Stigma is everywhere, even in the US. You don't wake up in the morning and you say, oh my God, I would love to file for bankruptcy. No, that's not how it works. But if the system can help you reorganize your business, maybe it's a possibility that you consider. And also countries like Australia, New Zealand, they have relatively attractive insolvency regimes for secured creditors, but in Australia, the regulators publish a report saying that on average, unsecured creditors get nothing. So nothing in an insolvency proceedings, and insolvency proceedings is supposed to be a proceeding to help unsecured creditors get something by preserving going concern value, by addressing collective action problems and asymmetries of information that might hamper this efficient allocation of the debtor assets. So there is something wrong with the Global South by looking at the Global North in terms of admiration. But of course, I'm not saying that the insolvency law in the Global South is perfect or is even good. Actually, I recently wrote a book saying that insolvency law in the Global South should be reinvented because there are many problems. There are even more problems than in the Global South. But actually, precisely because of that, because all the problems traditionally existing in the Global South has been thinking a lot about how to tackle many of these problems. And that leads me to one of the most extensive and probably exciting parts of my paper, which is to try to identify some of these innovative solutions that have been adopted in the Global South. And this is something that I've learned from a new global insolvency index that I've built. I've been working on that in the past 5 years, analyzing insolvency systems around the world and somehow challenging the index developed by Laporta and his co-authors. And I've been developing a new index, and as part of that project, I've been looking at insolvency laws from around the world. And even though the Global South generally replicate the proceedings and practices from the Global North, the truth is that there are, by looking at those systems more carefully, there are some interesting, innovative aspects that, in my view, and this is probably the most controversial kind of takeaway of the paper, should inspire legal reforms in the Global North. So in other words, the Global North should get the inspiration from the Global South for some aspects that, in my view, are some problems that, in my view, are happening in the Global North, and maybe they can fix by looking at what the Global South has done. One is the costly, lengthy aspects of insolvency proceedings in many jurisdictions, most jurisdictions in the Global North. Well, if an insolvency process is so costly, so lengthy, so expensive, why not restructuring out of court? So probably most jurisdictions in the Global North would say, well, that's a good idea to restructure out of court. But how can we make that happen? Well, some countries say we need to promote out-of-court restructuring, but they do nothing to promote out-of-court restructuring. Interestingly, after the Asian financial crisis, many countries, including Thailand, including India, including the Philippines, including Malaysia, adopted many innovative responses to promote, to facilitate workouts. Why was that? Because many countries didn't have a sophisticated insolvency framework. Many Asian countries didn't have an efficient insolvency process, an efficient judiciary to handle the wave of insolvency cases emerging from the Asian financial crisis. So that's why Asia had to be creative. And the way to be creative is by developing all of these innovative frameworks for enhanced workouts. Some of them were abolished, some of them were replaced, and some of them still continue today. And one of them is Malaysia. Malaysia has a fascinating framework for workouts promoted by the central bank of Malaysia that has been very successful. Even the IMF has said that it's one of the gold standards for workouts in the world. So maybe countries like Australia, countries like Germany, countries like Spain, because I'm not mentioning the UK and the US in particular because workouts are relatively popular in those jurisdictions, but many other countries in the global north maybe should look at Malaysia and should look at the Philippines that has also a very interesting system of workouts in the legislation to try to replicate that solution that can provide companies with a possibility to restructure without using the costly proceeding. Then also something that the US can learn from Uruguay. Part of the problems observed in the US now, well, there are a few problems in Chapter 11, apart from the cost, but also the fact that deep lenders are becoming very powerful, and also something that has been mentioned and criticized recently, like in cases like Johnson & Johnson filed for bankruptcy without being insolvent, and then the case was dismissed, saying, well, filing for bankruptcy in the absence of financial distress can be a kind of an opportunistic bad faith filing. So that's why the US has the discussion about whether insolvency or some financial condition should be required. So Uruguay decided to avoid that problem by saying, hey, we are aware that initiating the proceeding quickly is so important because companies are having problems and they need to have access to the hospital quickly. You cannot do like in India, where you, first of all, need to be almost dead in order to initiate the process. And once you are dead and you are knocking at the door, saying, please open the door of the hospital for me, I'm dying. The hospital say, wait a minute, I need to analyze whether you are really dying or not. And then after a few months in India, according to the statistics of the regulator, finally you are able to get the bankruptcy protection. That's crazy. That happens in many jurisdictions in the global north and many jurisdictions in the global south. And Uruguay decided to say that if the debtor files for bankruptcy, that petition by the debtor will serve as a non-rebuttable presumption of insolvency. So in other words, we don't need to analyze whether you are insolvent or not. So we will believe you, and also because the bankruptcy cost will act as a deterrence for opportunistic filing for bankruptcy if you don't need a bankruptcy process. But in order to address the criticism that may lead to abuse, Uruguay said, well, and also the creditors can terminate the process whenever they want. From day one, the general body of unsecured creditors can terminate the process if they believe that the debtor is using that opportunistically. Then also Colombia adopted many interesting provisions for the governance of insolvency proceedings. In many countries like Australia and New Zealand, many countries even in the global north, they have very unattractive insolvency proceedings for debtors. Once you file for bankruptcy, when you start administration in these countries, the management is replaced by an external administrator. That doesn't sound very appealing to me if I want to restructure my company. Well, Colombia adopted Chapter 11, but Chapter 11 with the possibility of appointing an insolvency practitioner just to monitor the debtor, not to replace the management team. Also, in terms of deep financing, one of the problems currently observed in countries like the US is that deep lenders are dictating the terms of the bankruptcy process. This is something that we have learned from the amazing work that Jared Elias and Ken Ayotte have done. Deep lenders and private equity sponsors are now the most powerful actors in bankruptcy proceedings in the US. And Jared and Ken have shown that deep lenders, because of the influence that they have, sometimes that lead to an inefficient outcome in bankruptcy, where, for example, the company may end up liquidated, piecemeal, even if going concern value is lost, or a distortion in the priorities in the bankruptcy process. So, and the discussion in the US is, well, but what can a judge in the US do when it comes to approving or not a deep loan that can save a firm, can save the employees, can save many things? Are you going to say no, even if the terms of the deep loans are somehow abusive? Well, Dominican Republic, good news, had the solution for that. The Dominican Republic has a provision saying that the creditors can veto the deep loan approved by the court. That's fascinating. Other countries go even further, like Chile and India. In India and Chile, the deep loans are approved by the creditors. In Chile, in certain cases, in India, always. But the Dominican Republic is something that, in my view, should inspire maybe the debate in the US, because the deep loan is going to be approved on the basis that it's going to create or preserve value for the benefit of the creditors. Well, if that is the case, why not asking the creditors what they think about that? So that's why the Dominican Republic can inspire the US. There are many other fascinating developments, but I know that I'm running out of time. So just to conclude, first, there are so many things to learn from the Global South. I identified at least 10 innovative aspect that should inspire debates and reforms in the global north. Then the question is, why are we observing this type of innovation? So here you can see Albert Einstein and Mariana Pargendler. So they have many things in common, like writing and suggesting many innovative theories and being very smart people. But for the purpose of my paper, basically I read that Albert Einstein apparently said that people become more creative in times of crisis. Then I read somewhere else that actually Einstein never said that. So I read somewhere that he said something that with crises there are more opportunities, and some people interpreted that he said something like that. But actually during the pandemic, we saw that people became more creative, and this is somehow what Mariana said. Mariana said that actually the Global South became creative when it comes to the corporate purpose debate because of the need to become creative if the government and the institutional environment is not suitable to achieve some goals that are good to promote social welfare. So that's why we need to include the Global South in the debate, not only because the Global South needs insolvency reforms and they would benefit a lot from these comparative studies, but also because the Global South can inspire many reforms and debates in the Global South. Thank you so much.
Thank you very much, Aurelio. I now give the floor to Akshaya.
Okay, hi everyone. I'm going to keep my comments more big picture because I obviously haven't built this index Aurelio has built, so I can't get into all the details of the laws he's got into. But let me start by complimenting Aurelio for the breadth of the paper itself, because it's goes into a number of innovative measures in different countries, and we don't see that in debates generally. I also promised some criticism, so here's some gentle critique. So I think Aurelio spoke about chapter 11 to begin with, and then we heard more about it, about how the Global South thinks of it as paradise. An alternative to this story probably comes from India, when the current insolvency and bankruptcy code was coming into being. There were people making various suggestions. I was one of the people saying, hey, we need a Chapter 11 style debtor in possession model, but everyone in India seemed to be just allergic to this word because we have a history of, there was a legislation called the Sikh Industrial Companies Act, which actually had Chapter 11 style model where the debtor company remained in possession. Now, all the bad feelings people from a certain generation in India have about the DIP model comes not from the model itself, but the way the Sikh Industrial Companies Act played out. Kristen Van Zwieten has a really good paper about this, where she conducts interviews to see why this was actually problematic in India. It turns out that it was really the judges in the tribunal that were in charge of actually bringing this, implementing this law. They were very, very, basically they were bleeding hearts and allowing companies to continue in operation whether the company was viable or not. So it ended up giving a very bad reputation for the debtor being in possession, but really it turns out that that's just how the jurisprudence developed in terms of how that act was cases under that were being decided. The reason I bring this story is not simply to challenge that, hey, it's not paradise in one country, but to say that it's great that we have these innovative solutions across countries in the Global South that can actually inspire countries in the Global North, but maybe we also have other types of lessons. Maybe countries in the Global North can learn from mistakes in the Global South. And also, I want to emphasize, although Aurelio did mention path dependence, that's something that comes up a lot in the legal transplant story of how, when laws are transplanted from the Global North to the Global South, it didn't quite work out so well because, you know, the way it played out was due to some local features, some historical features, so part dependence. So maybe the same sort of considerations will have to be kept in mind when we take these innovative features from the global south and put them in the global north. We should think about what the historical trajectory in that country has been. So having tried and been critical for a while, let me go on with some other comments which I think might be my reading of the paper in terms of how we can sort of the takeaways from this paper beyond insolvency law, right? So it reminds me of one particular chapter in a book where I was writing about CSR in India and ended with maybe countries like India are becoming norm givers rather than norm takers. Not that I'm a fan of the CSR provision, but it so happened that others seem to be inspired by that. And I seem to have a lot of pushback to justify that line, because there's a lot of discomfort in countries in the global north to even say that they will take ideas from the global south. So I think it's a great paper in terms of bringing it in through insolvency law, where things have been a little more open, particularly after the pandemic, because it really was a crisis that hit insolvency lawyers and thinkers and policymakers the most. So they were more open to looking around, picking ideas from different countries, so that was great. Aurelio mentioned some other catalysts for cross-fertilization of ideas, like the World Bank, which sort of was one-directional, one-sided. But perhaps there's a flow of ideas in more than one direction now because of some other reasons. What he didn't talk about here, but I saw it in his paper, was about technology, right? Many countries in the global south have adopted tech solutions to address some problems, and technology is now the shiny thing everyone wants to sort of see and incorporate. So maybe that's the sort of I don't know, the fad value of technology will inspire some countries in the global north to look to countries like Colombia, which have like this automated AI system to start the insolvency proceedings. The other comment I wanted to make was maybe Aurelio mentioned this in the context of Uruguay, where you said the default rule was debtor in possession, but there are other options. So I think this is a great way to sort of introduce something that you don't know how it'll work, because there are many options on the table, but you just change the default. So this is a call to the Taylor and Sunstein nudge theory, right? You're doing it, but in a very less interventionist way. So it sort of probably would be nice if this can sort of interact with other policy debates around this theory in other areas of law. And I think the final point I had was also about how the contributions of this paper, talking about perhaps there are ideas in global south countries that can inspire countries in the global north, going beyond insolvency law, because that's happened because of market necessity during COVID. But perhaps that sort of gives the impetus in other areas to look and think beyond. In the past, transplants had a bad reputation because they happened through colonization or IMF conditionalities or OECD requirements. We're a good investment destination if we have all the things you have. But doing it through insolvency law maybe gives it a better reputation, because we're trying to address some of our problems and we're looking around for ideas. It doesn't matter whether we look to the global north or the global south. Yeah, those were my comments. Thank you.
So thank you very much. Maybe just in the interest of time, before Aurelio reacts to anything that Akshaya said, if there's any other comment or a comment or two, maybe we can add it to that. Yes, Matsui-sensei.
Excuse me, my question is a little bit different, but my question is whether transacting parties are playing different role in global north and global south countries. In Japan, we have two types of bankruptcy and recovery workout type of insolvency law. And usually, directors choose workout because directors can remain as debtors in possession system. And in reality, in workout, related parties prioritize transactional creditors over financial creditors because transactional creditors extend credit by delivering materials before they receive money. and thereby extending credit to the company. And corporate managers cannot treat transactional creditors lightly if they are willing to continue their operation. Therefore, transacting parties will not suffer severely, while financial creditors are usually banks and they can give rational decision. And in global north countries, I have an impression that creditors transaction parties get paid as they deliver. And so the transaction parties are not playing a real role in extending credit. And so my question is whether this inequality of transaction and financial creditors also play a role in other countries in global south as well. Actually, for your information, it says that on average, preparing the rehabilitation plan takes 90 days in Japan, and then if you prepare them before going to court, it will take like 1 week. And then decision making among the creditors takes 60 days or something like that. Okay, thank you.
Yeah, thank you so much. Well, Japan is actually a fascinating country when it comes to restructuring. And many of my lessons for the Global North are actually targeting mainly the US, the UK, the countries inspiring insolvency reforms around the world. I'm not mentioning like specifically reform for Japan for several reasons. One is, as you mentioned, Japan has already a very sophisticated system for workouts, even facilitated through an alternative dispute resolution mechanism, and it has been very successful. Based on the statistics that I've read, apparently about 75% of companies that initiate this alternative dispute resolution turnaround mechanism are successful. And during that mechanism, you don't even have a moratorium, you don't even have a cram-down. So it's because many of the participants are repeat players, and many of the kind of social sanctions that may be associated if you don't participate or you don't act in good faith, that leads to a really successful restructuring. But then also when it comes to formal organization proceedings, Japan is also very interesting because it has more like the UK-style administration organization process for large companies, but civil rehabilitation as well. And civil rehabilitation is more like Chapter 11 kind of style. So Japan really provides a very comprehensive approach. But when we look at Australia, my apologies to our Australian friends here, or even New Zealand, so countries in the global north, actually for them, unless you use the scheme of arrangement, which is a debt restructuring tool, but it's not really a formal insolvency process, then the formal insolvency process means that the directors are going to be replaced. And then also you don't have access to new financing, you cannot impose the plan on dissenting classes of creditors. Australia has this crazy insolvent trading regime that is one of the toughest in the world. So that's why it doesn't sound like a very appealing mechanism. So to your point, so many countries actually in the global north, like the UK and the US, were leaders in pre-packs. They realized that initiating a formal insolvency process is very costly, very lengthy. So we're not doing everything before filing for bankruptcy, negotiating with all the majorities that we need. And then once I have everything, I file for bankruptcy, and it can even exit the process in the US in less than 24 hours. There are some 24-hour bankruptcy cases. So that was an innovation from the Global South. So my paper doesn't really cover that because that has been covered already in the literature. There are many papers saying, oh, how wonderful the US, how innovative the US people are, that they came up with the pre-packs. So my paper is really, hey, the Global South is also very innovative. So that's why the overall conclusion of the paper is that we need to learn from each other. I'm not saying that the insolvency regime in the Global South should be adopted in the Global North. No, because actually I emphasize that it's even worse, insolvency regimes in the Global South. But what I'm emphasizing is that there are some interesting features that might inspire certain specific debates and reform in the Global North. So that's why the overall conclusion is that we need to be inclusive when it comes to corporate governance or insolvency debates globally, and we can learn from each other.
Any other questions? I'll take a few. Steve, Jennifer, Chris.
Listen to Dan and come closer when he prompted me to. So really interesting paper. I just wanted to suggest maybe looking at the financial regulation literature, where after the global financial crisis, you did have a lot of jurisdictions looking outside of the global north because there was such a catastrophe. Now, I don't know if there is the same driver in the insolvency world where people may say, well, you know, you've mentioned Australia a few times. Things are generally going okay. The system hasn't collapsed. We may have some crazy rules, but it's working. We aren't looking necessarily to the global south, but just something to consider.
Yeah, just following on from Steve's point about, the global financial crisis. Of course, in a lot of countries we called it the UK-US crisis, not the global financial crisis. I've got an incredibly simplistic, it's so simplistic historical question. It has always puzzled me historically how both the UK and the US seem to be the great powerhouses of innovation and, success, financial success. And yet the UK historically had such a creditor-friendly regime where debtors went to prison, and the US seemed to be so creditor-friendly where you can become president no matter how many times you've gone bankrupt. And I don't understand that, how, they can be just totally opposite, and yet each was a powerhouse. So if you can enlighten me on that at some stage, that'd be great.
So a couple of quick questions. One is, actually done a paper before, it's on derivatives. So along with Gao Siming, I think you also know her, we study why countries follow the same global norm, even though the market size differ a lot. But anyway, similarly, it seems that here, there's some general trend, right? We kind of copy-paste from Chapter 11, but with some innovation here. So my general question is, what do you think is the key driver of why countries actually at least opt to copy-paste part of Chapter 11? And the reason for that. And I think there are some theoretical foundation, like maybe you can explore if you want to go deeper into other directions. But another quick question is, what do you think about the scholarship in shaping insolvency? The reason I would say that is purely from Taiwan, but it's not unique in Taiwan. Because in Taiwan, from my time in the UK, in Singapore, it seems that corporate law and the insolvency law are linked, right? Corporate financial law and insolvency are linked. But in Taiwan, it's totally opposite. Insolvency law is predominantly by civil procedural law. So those who teach insolvency law are civil procedure professors, which means that they don't know about finance, we don't know about them. And they always complain why banks always say no to their reform. But if you, from banking point of view, of course, they object, right? Because they are big creditor in the market. So I don't think Taiwan is super unique enough. Because I think, if I'm not wrong, Japan is similar, but China is different. Yeah. So I'm just wondering if you, whether those may be kind of the driver or kind of factor that actually influence how reform is done in a certain country. Yeah. Thank you.
And I'll just add on one very brief last question, and then you can just pick and choose for a few minutes which to answer. But it sort of builds on Chris's point, which is I'm curious whether you think this is by mistake or by design. And what I mean by that is, in stewardship, right, it was quite fascinating that in 2020 there are 2 UK reports almost written within months of each other. And one was a conclusion that the first decade of stewardship didn't work. And that, it wasn't working in the UK and something had to be done. And the other report was that it would be very bad if the UK didn't export this around the world, because the UK would lose their leading position. And I found that quite fascinating to see those reports almost side by side. It's basically saying, your legislation is garbage, but it must be exported. so I'm wondering whether is this the U.S. driving this through the World Bank, sending judges around the world? Is this an active campaign to spread Chapter 11, and that they know there's problems, but of course when these people go sell the product, they're not pointing out all the problems? Or is this some sort of passive thing that people aren't investigating it? And I'm just curious what you think about that. But just within 4 minutes, try to pick and choose stuff to respond to. Yeah, thank you.
Thank you so much. I wish we had like a few hours, maybe for the next Corporate Law Forum, we can have an entire, morning at least for insolvency, because I think this is a really fascinating area, and I am learning a lot from all of this interaction and comments and questions from all of you. So just to pick some of the questions. So one is, why Chapter 11 so influential internationally? Well, many possibilities here. So some people can say, well, people study an LLM in the US and they go back to their country saying, oh my God, this Chapter 11 thing is so fascinating. Actually, I read somewhere, and maybe our Japanese colleagues can tell us whether this is true or not, that somehow happened with the poison pill in Japan, that some people went to the US and said, oh my God, this is so fascinating. So we're not thinking about this idea here. And just to be clear, the point is learning from each other. The fact that you adopt a foreign law is not necessarily a bad thing. It's a bad thing if it is imported without comparing the legal, institutional kind of differences and without making any potential adjustments needed to the local environment. So why Chapter 11 so influential internationally? Also, I think it is because it's a very effective process. What do I mean by effective? When we think about insolvency proceedings, we need to think about effectiveness and efficiency. So effective is if you can achieve the goal of, for example, reorganizing companies. I think the US does a good job. Actually, David Skill and Ken Ayotte wrote a fascinating paper called Bankruptcy Proceedings, Bankruptcy Law as a Liquidity Provider for Companies. And basically they said that if you are insolvent but not in bankruptcy yet, you cannot obtain credit. Interestingly, if you file for bankruptcy in the US, you can already obtain credit. That doesn't happen in any other country in the world that I am familiar with. Once you file for bankruptcy, nobody wants to give you money. So why is that? Because of the law, in part, because of the deep financing provision, the fact that the new lenders will get a priority. I think there are many interesting aspects of Chapter 11 that can be imported, but can be imported with some adjustments. Because that leads me to my second point about Chapter 11. Even though it's effective, it's not very efficient. It's very costly. Actually, Jared Eliot published a couple of weeks ago a paper documenting the increasing direct cost of Chapter 11 and how the fees charged by lawyers and bankers in Chapter 11 has increased significantly in the past couple of decades. So that's why I think that sometimes people that study there look at the law itself. The law sounds appealing, effective, but then if they don't understand how it works in practice and whether it is efficient or not and to solve problems in a cost-effective manner, that leads to another problem. And then Chapter 11 has been very influential as well, in my view, because of the doing business. The doing business used to include many features from Chapter 11, so that's why it's not surprising that Chapter 11 was one of the best insolvency regimes in the world, according to the doing business, because the doing business was mentioning basically most of the features of Chapter 11. So that's why I don't think that that was done on purpose. I think that maybe the drafters of the doing business were just considering some of the features of Chapter 11, and then the efficiency part, the cost-effective part, was measured through a survey that was kind of criticized because that's not providing the reality about how it works. But I think those factors might explain why. And then why the US and the UK are so different. Well, actually, so David Skill, Brian Cheffins, and John Armour have been exploring part of that reason because there are many similarities among both jurisdictions in terms of capital markets, in terms of dispersed shareholding. And actually, David Skill was one of the first scholars saying, hey, the missing link in all of these discussions is corporate insolvency. So that's why I'm trying to bring the corporate insolvency debate always here. In part is we need to look at also the debt structures. That's something that they emphasize. When we look at the debt structures of companies in the UK and the US, they are very different. In the US, it's more fragmented, more dispersed. In the UK, more concentrated. So that's why workouts have been very popular. It's what they emphasize in the UK, precisely because the greater level of concentration in the debt structure has facilitated negotiations and out-of-court solutions, and because they were promoted by the Bank of England. And then if you don't reach an agreement as part of this, with this concentrated debt structure as part of this workout, then probably it's because you don't deserve to be reorganized. Or maybe it's because the creditors don't trust you. So then administration, where the management is replaced, can make sense. The problem is that countries like Australia or New Zealand have adopted the US-style administration proceeding, maybe without taking into account that in the UK, the workouts were very popular. And if the workout fails, then maybe there are reasons to believe that the management should be replaced. So I think there are some kind of factors that might explain these divergences. But and just to conclude with Akshaya, just thank you so much for taking the time to read the paper and to provide your very valuable comments. I cannot agree more with what you mentioned. It's like the global north should also learn from the bad experiences from the global south. I think the main point of the paper is not saying, hey, the global south should inspire everything. No, the main point of the paper is we should learn from each other. And unfortunately, what we have seen in most debates, in corporate law, traditionally, and in insolvency law, is that we have always been analyzing and admiring the global north, and the global north has been influencing. So that's why I would like just to conclude by congratulating the people behind the Asian Corporate Law Forum, my colleague, Puchniak, and all the institutions that made this conversation possible, because I think that we need more Asian corporate law forums around the world. Thank you.
Thank you very much. On that note, I hand it over to Andrew to chair the next panel.